are the entity, then very possibly their personal information could be out there, and it could come out in other ways if there's a domestic relations dispute, as you know, then all of that, it's all out there. So it really depends on what it is, what other collateral issues there may be that may indeed expose that information, unfortunately.
That's something that you don't think of when you do equitable distribution cases and divorce cases. If in fact somebody's going through a divorce and they have this big business, because I had a case before the court that was argued and they were trying to pierce the corporate veil because there were trusts and estates set up, and so the wife was a trustee, and so the husband, soon to be ex-husband, had his paramour living in one of the properties, and because she was a trustee. So what I'm getting at is that you have to be very cognizant when you're in businesses and there's divorce. Yeah. Because it comes through equitable distribution.
And it's all fair game. It's all
Not
all
necessarily, but you got to watch that,
So
because it could be.
Be nice to your wife, be nice to your friends, and be nice to your business partner.
Mediate and settle.
And be careful too. One other follow-up on that is, one of the questions is, well, are you incorporated? If you are incorporated, then your personal business assets may not be touchable. But if you are not incorporated and you're just Tom Smith Plumbing, with the sign on the van, and you're Tom Smith, then your personal assets will likely be
if there's a dissolution of a partnership,
right?
And assets are there, and there's always ugliness around what's where and what's with who, and what's my personal asset as opposed to an asset owned by the partnership. We get that a lot. So then all of that has to be exposed to figure out what are the partnership assets versus personal assets, and that comes up quite a bit in when things come undone.
Wait, just one more follow-up to that. Just so you know, if you're incorporated, you cannot, as an individual who owns that company or a member of that company, cannot appear in court on behalf of that company. You must have a lawyer. If you're unincorporated and you're just operating as Tom Smith Plumbing, my example, then you can show up in court to represent yourself. We talked earlier about pro se litigants. I think that's something that a lot of small business owners aren't aware of, because I see a lot of them at the trial court, I did anyway, trying to show up to represent themselves. And you're not permitted to do that if you're incorporated. You must have a lawyer.
Okay, the gentleman. Well, you want to come up, but I think they want to hear the
While he's
microphone.
coming, I'd like to recognize President Judge Hughes, who came in from Luzerne County.
Yay!
One other facet to discovering financial information involves cases where there's a claim for punitive damages against a business entity. And so long as there is a prima facie showing that there was reckless indifference or an evil motive, something of that nature, outrageous conduct, discovery can be undertaken to ascertain the net worth of the defendant entity or entities.
Yeah,
so
that's right.
Just thought I'd add that.
Yeah, well, that's great. Well, thank you, President Jones. Thank you. Because, so in other words, it's fair game. It could all be out there, especially if things come undone, if a partnership is dissolved or a marriage is dissolved and there's a fight over, what should be part of the equitable distribution, what should not be part of it, and how much is it worth, and, somebody trying to hide something, and, and all of that stuff.
We have time for one more question.
Anybody else?
We go.
Oh.
Pardon me?
First, I just wanted to recognize Judge Hughes has entered also as well. So,
yeah, welcome.
I kind of wanted to follow up on Bob's question when he was talking about complex commercial or commerce cases. We were talking more from county to county. You had brought up, for example, a food poisoning case. If you've got something that's interstate versus intrastate, how do you determine whether or not it goes through the state judicial system or whether it goes through the federal judicial system? And if you went through the state judicial system and topped it out maybe at the Supreme Court, how do you know then that you might be able to litigate that within the federal judicial
Well, many
system?
times there's something now, you may have heard of SNAP removal, where a party may file an action in a civil court in any of the counties and state court, and before it's served, a defendant can literally snap it and file it in federal court. So it's called snap removal, and the Third Circuit has approved that. So a lot of times the parties figure that out, where they want litigation to be, even before the judge can make a decision, because the judge doesn't weigh into that at all. I mean, that's something among the parties, usually defendant, because the view is, many times from the defense viewpoint, that a federal court may be more favorable. They might get a more favorable venue than a state court. That is totally acceptable. And as I said earlier, so even between counties, some parties may want a Philly jury, somebody may want another county, so they might try to figure out. I had a case where one party filed in one county, then that party was served, and they went ahead and filed in another county and counterserved. So you had two counties with active complaints with essentially the same action, but each party had proactively figured out, I want this county because I'm perceiving that's better for me, or the other party's thinking that, and then it ended up, a judge had to figure out which county had the sufficient contacts. I'm sure you all remember from law school all of that stuff to figure out where cases belong. So many times the parties will try to file or snap, in the case of it snapping into federal court suddenly, before the judge can even weigh in on where it might belong, even making a decision.
One last question.
Okay.
Thank you. It'll be obvious from my question that I am not an attorney. So I'm a goldfish in among the sharks. I do anticipate having a need for the Commerce Court. Do the judges on the Commerce Court have special training, or do they have extensive experiential backgrounds to serve on that court?
Well, there are only, presently, there are only 2 counties that have Commerce Courts, and possibly a third is coming in Luzerne. So you have Philadelphia County, Allegheny County, and Luzerne County is coming. I know in Philadelphia, and I don't think it's any different anywhere else, you know, judges, when we start, all of us come to the Common Pleas Court, if we're elected in Common Pleas Court, from various experiences. Some have careers in the criminal court as a defender, as a prosecutor, in private practice. I was a civil attorney. I worked in the solicitor's office. Councilman came in with different experience, and Maria was with the DA for, was that 19 years? So you come to the court with different experiences. Nobody comes to the court with experience in all of the areas of family, orphans court, civil court, and criminal court. You come with an experience in the career that you practice. Once you get into the court, you're elected, then you start usually in family or criminal, then move to civil. And I know the attorney, I don't know about as much with the judges in Allegheny Court, but I know the judges, I know personally in Philadelphia Court, very experienced long-term civil judges before, you know, they went to the specialized area of Commerce Court. So they were very, very experienced in civil litigation before they were assigned you know, to the Commerce Court, and I'm sure it's the same in Allegheny County as well. So these judges are very, very, very versed in civil litigation and in business disputes before they're assigned to Commerce Court, because of it's a specialty court. It's almost like a boutique court, a niche court. So you want to have judges that understand the complexities and the kind of idiosyncrasies of complex civil litigation. So that's kind of the top of the pyramid in civil practice for a judge to get to that court. So they are, and the answer is yes, they're very experienced in civil litigation before they're assigned to Commerce Court, and I'm sure it's the same in
And the
Allegheny
4
County
lawyers
Court.
that are assigned to Philadelphia are from the business section of the Bar Association. Yeah. So they are experienced business lawyers, and they're 4 full-time lawyers that work with the judges in Philadelphia in the Commerce Court.
Thank you for making the effort to be here. It's been highly informative to me.
Thank you. Well, thank you.
Wonderful job.
Thank you.
We are going to open up the refreshments in a moment. First of all, we were joined from Luzerne County by Judge Tina Gartley is here. And just three quick things I have to say. First of all, isn't this facility magnificent here? Lackawanna College is just beautiful. And there's two people who are really primarily responsible for getting us here, and we want to take this around the state. We're hoping that our western judges will schedule us in Allegheny, and our southeastern judges will schedule us in Philadelphia. But one of the primary reasons we're up here is two people, and the first one, and it was actually based on a discussion we had maybe with a glass of red wine in our hands, but it was Dominic DeNaples and I who first talked about this, so I wanted to thank Mr. DeNaples. And believe it or not, I would have never done this without Joseph DeNaples and all his help along the way. So, Pat Solano was here. I guess he had to leave. I can't tell you the respect and esteem all of us have for Pat Solano.
94 years old, so he's entitled to an early quit.
He's allowed. He's allowed. So, well, we thank all of you, and please join us for some refreshments. Thank you very much.
Thank you, guys.